Welcome to episode 3 of Courtroom Stories. Have you ever wondered why there are some lawyers who get judgments every time they step in the courtroom while some others but are unable to deliver?
Who appears should not make a difference. Whether somebody A appears, B appears or C appears. If bail ought to be granted, it should be granted.
Why there are some lawyers who have great arbitration practice.
So if you enter the courtroom as a judge or as a lawyer and you are well prepared with your brief, then you are going to be in the driver's seat.
He's had a great career as an arbitrator, as a mediator, a lawyer and a judge.
I used to write each and every word of what I would have to argue in court, including writing on top, "May it please your lordship."
Served the Delhi High Court from the year 2006 up till the year 2020.
You have a common canteen for judges?
We have a judge's lounge. But let me add a word of caution. It is also said, just be a little careful of that fellow. You see, indulges in a lot of sharp practices. So your reputation travels. Good travels, bad travels. Which court will hear, no? When it comes to the lower court, they have to give the numbers. When it goes to the Supreme Court says, look, you come through two courts. Somebody has to say, all right, I want to hear you. For the common public, judges have a 5-day week. If you ask a judge, he's working even on a Sunday. You enter the Delhi High Court parking lot on a Saturday and see the number of cars.
Is it better that judges should be rather paid a better salary versus given all the perks that are given?
It's the trend. We've allowed people to do institution bashing.
So thank you for joining us today and taking time out from your busy schedule. I very fondly remember, even though I've known you for more than 20-25 years, one of my first appearances was in fact in your courtroom somewhere in the year 2012-2013, and I still remember I wasn't the most well prepared, and when I appeared I kind of had a moment which was more like a brain freeze. Mm-hmm. And you were kind enough to not say anything to that, but I just want to generally understand, a lot of young lawyers who also tend to appear in their first year, second year, they become very conscious of what they have to say, and, they plan their whole structure of argument but are unable to deliver.
Thank you, Varun, firstly, for having me here. When youngsters appear in court, they do have different reactions, Some youngster may tend to speak very quickly. Somebody may be extremely soft and his or her voice may not carry. Sometimes they're not able to communicate, right? And I actually, if I may use the word, blame everything to the senior they're working for. So it's the duty and responsibility of every senior when he pushes a young lawyer in court to tell him what to expect.
Right.
If you tell him, go and take a Passover. Yeah. Well, that's not enough. If it's a matter where you have not been appearing or you are in default, and you know that the judge is going to be upset about this, don't throw this young boy or girl to that situation, right? And if you are going to, because he or she is going to face this situation sometime in life, then you have to explain that, listen, we are in default. Yeah. We have not filed our reply, but it's for good reason. A, B, C, whatever, or our reply is ready. While you seek a Passover, if the judge says, why have you not filed your reply? If the junior has no idea what reply karna tha, nahi karna tha, he will not be able to answer. But if he says, yes, we are in default, but my reply is ready. I'm carrying an advance copy, or I will file it during the course of the day. It sends two signals. Firstly, that default is likely to be covered. And secondly, that the person who's entered the courtroom has some idea. Because, see, don't forget, average judge is handling 60 to 70 cases a day.
Correct.
He or she may not have enough time for pleasantries, right? So, while you may be a busy lawyer, but you owe a responsibility to the court as well. So, while the senior must guide a youngster, the youngster must go through the file. He can be faced with a situation where we've been faced with such situation. I don't want to name. When you entered the bar room, one gentleman, he would always say, he was a government counsel, he would just hand over a file to me. He says, pesh ho jayenge. You don't have to wonder, what do you mean pesh ho jayenge? But he would not get up.
Right.
So it was up to you while running in the stairs or taking the lift to understand what do you have to do, right? And in the long run, it came of great help
Right.
because then you picked up what to look at.
Actually, very interesting point you make, and I think part of the reason why anybody should not have a brain freeze is because if they're well prepared, then they probably will be a lot more easier. But interestingly, you mentioned another very important aspect which I also at a lot of times struggle with, and I happen to try and deal it my own way. I mean, I've tried meditation, I've tried different forms to remain more, let's say, poised during court proceedings and not run through my arguments. But since you are known to be, very popularly a person who has remained calm during all the times that you've been as a lawyer, as a judge, what advice would you have for younger lawyers who tend to run through with the arguments quickly?
It's not difficult.
Right.
And this is not only for lawyers. This is for maybe judges or maybe anybody.
Right.
It could be you, me, a staff member, somebody on the road,
Right.
A doctor, an engineer.
Yeah.
See, the first mantra is, as a lawyer or as a judge, you must read your brief. So as a judge, if you have read your files, see, barring a few who are Mr. or Miss Know-it-all, we don't know everything of everything. It's not possible also. Must admit it. Some things are run of the mill, some are not. So if you enter the courtroom as a judge or as a lawyer and you are well prepared with your brief, or if you have read your files, then you are going to be in the driver's seat. So you are bound to be calm and composed, unlike a person. So suppose that lawyer on the other side is very well prepared. So he will presume certain things. So he will start with a particular argument, not realizing that this man has not read his file for whatever reason. Or he's read his file, but he's not on the same page, right? So sometimes as a lawyer, it's a good idea to say that although I know you would have read the file, but may I just in my own way give you a bird's eye view. So that will give you an opportunity to know where to touch and what to touch upon. And the judge will get an idea as to which way to move on. He may pose certain questions during that period where you say it's a bird's eye view. Correct. So I cannot boast of saying that I would read every line of every file.
Right.
But I can tell you very frankly, I would read all the files. Whether it was admission matters, whether it was regular matters or after notice miscellaneous matters, depending on the time I had, it is not as if I never knew what is in the file. How much deep I went into it depended on each case. But admission matters 100%. So if you read your file, there should be no reason for you to be in an irritable mood. Right? And you're doing your job. You should be happy. You should be grateful. There is a question of being, say, edgy or, pounce at people, or I don't see there should be any reason.
I'll give you a small example. I know for a fact, I mean, I've seen this in matters which do not necessarily have great amount of merit, but on the other side, if the other side doesn't have a great amount of merit and legal issues to argue, they try and instigate you to derail the main line of argument and, try to hyperventilate the court proceedings as well.
Yes.
In those proceedings, how do you remain calm?
It's nothing new. It's nothing new, Varun. Let me tell you that. Even as a lawyer, I have engaged Mr. XY, knowing that he will go there and there will be fireworks. And that will be the end of the matter and it will get adjourned for 2 months, 3 months, right?
Yeah.
The first thing which I tell everybody, please don't get drawn in.
Yeah.
Once you are in that situation, tu meme wali, and you get drawn in, then you don't know how to get back.
That's the catch-22.
Right? So that is the first thing you must be very careful. But mind you, I'm not suggesting that you should be weak.
Yeah.
I'm not suggesting that you should not be firm.
Yeah.
But what I'm underlining is you should be very polite. You can be polite yet firm. You don't have to hit below the belt.
Do you want to name one person or one habit which you particularly were very fond of a lawyer or a senior advocate, which made their arguments a lot more simpler or, easier
See, I'll
appreciable?
tell you two things. one, even as a lawyer, you should know when to put the full stop, right? And you carry that reputation. I'm not saying you don't argue a weak case well. There are lawyers who argue weak cases with as much gusto as they argue a strong case. But then after a point you realize that that is it, right? And you must take the hint. Like I would normally say, maybe in a better matter, I think you've done your best, right? Please reserve it for another day. I think now you're wasting your energy. That's another way of saying, you understand. Just a way of saying, okay, that's it, right? Somebody may throw the file. Somebody may have another reaction. So everybody's different.
Right.
It doesn't mean if somebody has a stronger reaction, his sense of justice is less.
Correct.
Right?
Yeah.
But a person must also keep in mind, nowadays we all say, look, we don't have the luxury of time.
Right.
But then, which court will hear, no? When it comes to the lower court, they have to give the numbers, right? When it goes to the Supreme Court says, look, you've come through 2 courts. Now we are not going to get into the factual aspect. Then some court has to hear, no? Somebody has to say, all right, I want to hear you. At one time, I never liked hearing parties in person. And in the latter half of my journey, I realized that sometimes this man knows much more. At least he's able to convey where the shoe is pinching. Sometimes lengthy and complicated judgments don't reach the litigant.
That's true. Yeah, I was actually more straying on the qualities of a good counsel. Like, is this one quality which you would really attribute to getting you more favorable orders than the others?
See, when you were talking about young lawyers, no?
Yeah.
I will share something with you. I used to write each and every word of what I would have to argue in court, including writing on top, may it please your lordship. This tongue-tied business you were talking about, no?
Yeah.
So I'm saying everything used to be handwritten. And page number, annexure number. See, what irritates a judge is that fumbling, the annexure, page so-and-so, oh sorry, it's wrongly numbered as this, but you will find it there.
And currency.
See, that should not happen.
Correct.
That is something which shows that you are not ready with it. You must flag your file. You must have the page numbers. You must have where is what. और जैसे कुंजी नहीं बनाते, वही बनानी पड़ती है. Anybody who can make it, he is able to communicate.
Better.
And again, the judge would know that this man would have done it. So even if he is talking to the other side's lawyer who's fumbling, he will look at you, knowing that, look, तुम्हारे पास है. So show me. Right? And I must tell you, there have been times where after a hearing, a judge has said, all right, just hand over your written notes.
There are some lawyers who enter the courtroom and they win literally almost most cases, where there are some who could be well prepared, will have the legal information or the knowledge, may not get that desired result. What is the difference between those two? As in, would you agree? Firstly, would you think that
I don't agree.
No?
Let me tell you.
There's some carry better reputation. Like there are.
See. Then what about the case? What about the merit?
Right.
Right?
Yeah.
Who appears should not make a
Much
difference.
Right.
If it's a case for bail,
Yeah.
whether somebody A appears, B appears, or C appears,
Right.
if bail ought to be granted,
Yeah.
it should be granted. And if bail is not to be granted, it should not be granted,
Right.
irrespective of who appears. In a lot of courts, a lot of people feel it's not necessary to carry A, B, C.
That's true. But there are ABC who are, charging big bucks, who are doing well. If there was, I'm only asking these questions for someone who wants to become like an ABC, right? If there was any particular reason you felt that ABC are, carrying that kind of reputation to charge that kind of fee compared to the others.
See, on the scale of 1 to 12,
Yeah.
1 to 10 is hard work, and hard work.
Right.
The balance 2, you can say some good luck or something.
Fair point.
you can be placed in a great situation.
Yeah.
You can inherit your father's library. You can inherit a name. You can inherit some position, etc.
Yeah.
Ultimately, it will melt, Varun.
Yeah.
Let me assure you that.
Correct.
You know, I mean, I always give the example of a doctor.
Yeah.
Will you go
To a doctor's son.
to a doctor whose son, or will you go to, you will ultimately go by the person who is
Delivering.
who knows his job.
Correct.
You can be placed well.
Yeah.
You can get that little push.
That's true.
But you hear a lot of success stories.
Yeah.
But go down in history,
Yeah.
and you will find a lot of second generations
Yeah.
have been flops.
That's true. That's true.
Not everybody is like you, but it's easier. People are, because that's a place, it's a position, right? Your father can say, "Bhai, I was the managing director, now X will be managing director." It's his company. It doesn't happen in court. You can't say that today, now my son is my successor. They'll all go away. So you have to earn that. There is an advantage. There is an initial advantage. But that advantage will fade away if you are not able to deliver. Another person who doesn't have that advantage will take a little longer maybe. But it is not as if he will not be detected. He will be picked. Generally in court, during lunchtime, one normally says, that youngster has been appearing in my court. I think he's really good. This is a normal conversation. Yes. See, we sit in different jurisdictions. So somebody who's sitting on the tax, will talk about a person and say, look, he or she has been appearing in tax matters. I think she's fantastic. She's really good. So you do get an idea. Somebody who specializes in maybe arbitrations or the original side, and a lot of senior judges don't sit on the original side after the initial years. So they will say that, that youngster is shaping up very well. But let me add a word of caution. It is also said that, just be a little careful of that fellow. He, indulges in a lot of sharp practices.
Oh, so your reputation travels very fast.
So your reputation travels. Good travels, bad travels. Bad tempers travel. What happens? First thing when you reach the canteen, if your matter has been dismissed, what do? You say, this fellow knows nothing, right?
I don't indulge into such conversation. I go back to court.
I'm saying there's so many things that people would say.
Yeah.
And the same thing happens when you go and talk amongst yourselves.
Yeah, I didn't know that. Do you have a common canteen for judges? No.
We have a judges' lounge.
Okay.
Everybody says it's one of the best high courts. And the inter-se relationship amongst the colleagues is excellent. We all had lunch together in the lunchroom, barring a few people who had a special diet or something like that.
Okay.
But they would join in for tea after that.
Mostly all the 40, 50.
Yes.
Oh, wow.
And
that must be going through a change because lots of people from outside are now coming in. I mean, I'm not trying to...
Delhi welcomes everybody.
Yeah.
Let me be very frank about it.
Yeah.
Delhi welcomes everybody. And Delhi is such a place where we have always had judges from almost every state.
Yeah.
Whether it is Andhra, whether it is South, whether it is Kashmir.
Yeah.
Everywhere.
Yeah. I, in fact, want to come back to a very more important topic which came from what you just mentioned, that because, a lot of people from the original side don't want to go back to the original side. I was actually wanting to broach the topic of roasters. My question is that if it's allowed to do for a long period of duration and to ensure that there is more continuity, then why is it that after a point of time they remove? Because I'll tell you for a fact, there are some cases, I mean, I've seen it on the service side or sometimes even on motor vehicle side, that they are pending for so many years only because somebody has heard it to a great extent, and by the time they get ready to dispose it off, the fate of the matter is such that it just stays on like that.
It is good to have a specialist. But, you may like to rotate some of the younger judges who have long tenures so that they can deal with different jurisdictions. And it is, and to keep a judge for more than, 6 months is generally the roster changes, but there are judges who have been asked to be retained. For example, I was on the original side for a year, on the criminal side for a year continuously. And that is for the element, because the Chief Justice gets figures. So the Chief Justice also has to see that there are disposals. And he does get an idea, where and why certain rosters are not moving. Could be for many reasons. A judge could be doing, there could be some bulk matters, collective matters, so they may take longer. But the monthly figures do come, right? So a Chief Justice would, at least a proactive Chief Justice would like to see, how to make sure and where is the backlog coming up or whatever.
So it's in essence trying to improve the efficiency. That's what you're saying.
That's the objective.
But sometimes it gets lost, but that you can't really help.
It can get lost for various reasons.
That's true.
Sometimes there are constraints with the Chief Justice in, putting whom to put where.
Yeah. No, actually, this opens up a whole round of discussion on many such aspects. But before I get into all that, I obviously have a very short career and I haven't seen much, but I have a feeling that maybe 5 years or 7 years back, because Delhi High Court is probably the most sought after in terms of the way it operates, the way it gives orders, everything. And I think it still continues to, have that reputation. But I think from the past to now, what may have changed a little bit is that there are lots of matters that if they are passed over once, they will never reach. Right? And I think that it's obviously lead to the fact that there is a lot of explosion of briefs as well. And you can't really blame that.
See, it's a number game, really. If you can see that the ones which some only procedural order is required, one should just run through them and not keep them. So that's one way. Right. Then there are some others which are short matters, which require little more attention. And then you hold on to the longer ones. Right. So a lot of matters during the COVID time, where that was one of the big reasons. And mind you, judges are sitting way beyond the court time. It's still 4:30. But what I understand is there are hardly any court which is getting up at 4:30.
In fact, there's many of them sitting on Saturdays also now.
See, again, for the common public, judges have a 5-day week. If you ask a judge, he's working even on a Sunday. Right? Yeah. So nobody has to justify anybody. Correct. You enter the Delhi High Court parking lot on a Saturday and see the number of cars. You will get an idea whether Saturday is a holiday or not. The only difference is that on a Saturday, at least I would not go at 10 or 10:30. I would reach at around 11 o'clock. Right. But other than that, you will find 80% of them in court on every Saturday.
Yeah, and in fact, that you've touched a very interesting part in this discussion about the kind of backlog. And I want to actually ask that, and I'm sure any person and every person who is in the field of litigation or is aspiring to be a judge would want to understand this, that if you're doing 50, 60 cases a day, and that too for an extended period of time, for let's say 5 years, 10 years, some 10 years last even longer, where is that? How do you draw a line? How do you end up coping up with this? Sure, there has to be a lot of physical, mental fatigue with all that.
There is, and there is bound to be, because a lot of people who write and who share their views are the ones who have no idea as to what is the daily routine of an average judge, whether it's in the High Court or in the lower court or in the Supreme Court. So, because they get to see only the glamour part. They will talk about some ribbon cutting, something here and there, some comment made, etc. That's not reality.
But what would your piece of advice be for people who are aspiring to be judges? How do I tell myself that I'll be doing 60 cases for 10 years and I'll still remain?
It's the honor and respect which is attached. It's the sense of satisfaction. It's not the glamour, surely not the money, right? Yes, honest people of integrity, they certainly must aspire to be judges. And why not?
But that's actually two very interesting points from there. One, first, that in the recent you mentioned the fact that about honest, and I think the recent turn of events where the whole cash burn row, which, I mean, according to me, I took it as like a personal loss, because I genuinely felt, I mean, the man who was delivering those orders was too good. But after that, I'm sure industry in general has taken a hit, and there is a discussion about it. Is it better that the judges should be rather paid a better salary versus given all the perks that are given? Or do you think, how do you instill more? Because
There's no relationship.
there's no relationship.
It's a matter of contentment. You see, it's never enough.
Correct.
If it's 5, why not 10? If it's 10, why not 20?
Correct.
Right?
Correct.
So ultimately, there is a term which is being used, has been used, and will continue to be used, is judge material.
Yeah.
Who is judge material? Right?
question.
Sometimes you will say that he's an excellent lawyer,
Yeah.
but he's not judge material.
That's true.
Right? Now, what is this judge material? See, when you're sitting in court, as lawyers assess judges, judges also assess lawyers. Their conduct, their mannerism,
Correct.
their sense of fairness, their balanced arguments, their balanced demeanor. So there is so much. It's not like you give an exam. Suppose you give an exam and say this fellow scored 99 or 90. You can't make him a judge because he scored 99. There has to be much more in the making of a High Court judge. It's just not how much law he has studied and how many sections he can rattle off. But the idea is how balanced he is in his approach. What is his sense of justice? And mind you, we've dealt with cases and continue to deal with cases of hundreds of crores. You think it makes a difference? Sitting in court, you deal with all sorts of matters. You think it makes any difference to a judge? Not at all. Yeah. I mean, these people have this wrong feeling. And that's because this is the trend. We've allowed people to do institution bashing. Well, I'm not here to justify and say that, everybody is A+ and all that. I'm not saying that. We may have had our problems. Yeah. We have our problems. Yeah. But just don't do institution bashing without any knowledge. He's X is corrupt. How do you know? No, so-and-so was saying. How does so-and-so know? I don't know. No, that's no way. Right. And if you feel and if you have information, that don't leave it there. Then go ahead, take your action.
Do you see, with the growing this social media explosion of people bashing and without knowledge bashing, in order for a more image correction, ki matlab, like we always say, justice is not done, it should be seen to be done also, right? So is it for the purposes of image correction, if I may ask, there needs to be some reform in terms of how is a judge who is maybe held accountable or who is found guilty of doing something foul play is dealt with? Because clearly, I mean, wanting the 2/3 of the member of parliament to, take him off will not definitely suffice.
Let me tell you. It's not that we don't have in-house procedures.
Right.
Even in the past,
there
have been times when the Chief Justice would have called a particular judge,
right,
and cautioned him.
Right.
And there are ways, right? But public perception is one thing. Public opinion is another thing. Today, you can create a public opinion. There are people who are paid to do that. And you can create a public opinion of anything.
That's true.
There are people who will engage people. What are they called? Influencers. What are influencers? Right? They will influence people on a particular product, on a particular person. The personality cult will be made of a person. And we'll all be talking about he or she, etc. judges are much stronger
Yeah.
than what people think they are.
Right.
If they are to be swayed and persuaded by what comes out in newspapers or social medias, you think the judgment or the order which is going to be passed the following day
Yeah.
is dependent on what is written in the newspaper? I don't think so. And it should never be done. Because you know what's in the file. The people who are writing on media, etc., they have no idea.
Yeah.
And they don't want to know.
Yeah.
They just, whatever is there, they will follow it and then they will start.
Right.
You've seen it happen. You've seen our electronic media also.
Yeah. No, it's too powerful these days. In fact, I thank you for broaching a very interesting topic. And although I have some reservations about judges in the lower judiciary, but I'll refrain that and we'll keep that for another day. But on media trial, which you were mentioning about,
That's very dangerous.
Today it's happening to such a large extent. How do you? I mean, did you ever feel the pressure during any particular case, or do you feel that it does take place?
Let me tell you one thing. You hear so much about this pressure, that pressure. I'm saying so without any reservation. I have never ever had any pressure from anyone. Because initially some people have no idea.
Yeah.
Then people know about the reputation.
Yeah.
So the idea is there is no point. That person will only do what he has to do. So people don't want to waste their time and money on such people.
Right.
So if you don't give in,
Yeah.
nobody approaches you.
Yeah.
But if you are ready to be approached, then why should anybody not approach you?
So there is that you admit that there are some people
No,
who will
it's-
have that reputation.
No, you see, like I said, there are black sheep everywhere.
Yeah, that's
There
true.
can be one or two people. But if you talk as a court as a whole,
Yeah.
I can say so, in spite of what you have said. See, I know an eye is a very good witness and much better witness than the ear. But we don't know. We don't know the circumstances. Yes, something which came up, it should not have happened the way it has happened, etc. There may be 100 things to it. We don't know as of now. Right? As you said, the person had carried an excellent reputation, excellent background. How, when, where, why, I can't say. What is the solution?
That's what I want to talk about. Yeah.
The solution is that unless and until we expose, right?
Correct.
High Court has power of superintendence under Article 227.
Correct.
But the High Court doesn't sit in the lower court, right?
Yeah. Yeah.
So somebody, and mind you, we get all sorts of letters,
Yeah.
complaints.
Yeah.
But some complaints are, why is the judge giving short date?
That's
Why is he
obviously.
giving long date? He was rude to my lawyer, but he was not rude to the other lawyer. So these complaints pile up. The High Court scrutinizes each complaint. And if there is some merit, the High Court does take action.
Yeah.
Sometimes we get a complaint saying that my judgment has been pending for so long, he just gives dates.
Yeah.
So discreetly the file is checked
Right.
to see whether what he's saying is correct or not.
Right.
And if what he's saying is correct,
Yeah.
the message is sent that, listen, some complaint has come, make sure you do it next week or whatever is the next date.
Right.
Right? But once it goes beyond, you're talking about the level of corruption,
Yeah.
then there has to be at least a complainant.
Hmm.
People want you to take action and cognizance without a complaint. How can that happen?
That's true. I mean, somebody has to be a whistleblower.
Somebody has to be a complainant.
Whistleblower. Recently, some people were transferred from one court to the other. And I'm not obviously talking about that incident. Even otherwise, there were resistance about judges being transferred from one court to the other because the other court was complaining that if there is any allegations of misdemeanor, then why are you treating transfer to our court as a punishment? I mean, that was also not a solution in that sense.
This is also not a solution.
Correct.
This transfer business is no solution.
Correct.
This, unlike services,
Yeah.
where you have your batchmates, you have a
Compulsory
Sainik
retirement.
school, you have your own systems, etc. Once a judge is transferred,
Yeah.
he goes into complete isolation,
Yeah.
right?
Yeah.
And there is hardly any support system because you are going to another state. It's a completely foreign state for you.
Yeah.
Then what is the objective?
Hmm.
There has to be
Some objective.
some objective.
Yeah.
What you are saying,
Yeah.
transfer is not a solution for that.
Yeah. For corruption.
It's not a solution.
In fact, why not have compulsory retirement?
No, I'm not on that.
No.
I'm saying if there is,
Yeah.
it can't be
Yeah.
that this is my report.
That you send him there elsewhere.
This is not what
If he's
report.
doing here, he'll do it there also.
He will do it there much more. Because if at all he's doing something here,
Yeah.
you still have some peer pressure, checks and balances. Outside there is none.
Correct. He'll have it.
So I'm saying whatever is to be done
Yeah.
should be done.
Right.
But जिसको हम कहते हैं कान के कच्चे ना नहीं होना चाहिए.
That's true.
ये नहीं होना चाहिए कि आपको लगे this something is come from here, something is come from here.
Yeah.
What don't we know how gossip starts?
That's true.
Mostly it is gossip.
Yeah. That's true.
A will tell B, B will tell C, C. This Chinese whisper goes on, no?
Correct.
So this is one thing. You may have another policy.
Yeah.
You can say, all right, we want this thing. But see, it's not easy. Type of cases, court culture.
Yeah.
It takes time for people to settle.
That's true.
And Delhi is that way cosmopolitan.
That's true. We also want to understand that what is actually like a life of a judge.
You know what a lot of people talk about judges and holidays, and we get to hear a lot of things as jokes. Today I saw so uncle's car standing, so I didn't send my child to school. So of course it's a joke. So no, because lawyers and judges get more holidays than even school children. See, now visualize an average judge has 60 to 70 cases every day. So let's say you reach, court starts at 10:30. So let's say that some people are morning persons. So he will read his files in the morning. I was not a morning person. So you reach court, some people would reach at 10, some at 10:20, some at 10:28, whatever. So court starts at 10:30. So official lunch break used to be 1:15. But there is hardly any court which will get up at 1:15. You as a lawyer would know.
Correct.
Even if the person wants to get up at 1:15 for more than one reason, including running to the loo, he would be stopped. And that stretches till 1:30 or 1:25. So you race to your chamber, you will go to the loo, you will wash your hands, whatever, and you will go for your lunch. So when you return after lunch, your secretary will say that, look, in the morning there were some urgent orders which you had dictated, and there is some injunction or there is some bail or something or the other. So you are going to stretch a little bit during that time. Sometimes you will come early from lunch. Okay, there's an urgent order to be corrected and signed. So then that 2:15 or 2:30, I am being very candid, sometimes you sat at 2:30. And once you become senior, there is administrative work also. So then court finishes, say, let us say 4:30. I don't think there is hardly any judge who actually gets up by 4:30 ordinarily. There are days where the list may collapse, something or the other may happen. So let us say 4:30 or 4:45, you come back to your chamber. Now, the orders you have dictated during the day are required to be signed. Some of them are short orders, some are very short orders, and some are slightly longish orders. So while you are changing out of your uniform, you are actually signing the short orders. And that will take you a good half an hour. The longish orders, which is let's say about 10 pages or 15 pages, etc., will not come to you by that time, right? So some of us would take a break around 5:30 or so, and it would stretch maybe for half an hour. Sometimes if the gossip session was slightly more, it could be even 45 minutes, or if you had a meeting. So once you come back to your chamber, you will have some more orders to sign. And the files for the next day, which is again 60 to 70 matters, will start trickling in, right? And there will be bundles and bundles. So here, now if there is urgency in some order, you will leave those files there and you will work on that. If those orders can wait, then what I would do is, I would divide these files. The fresh matters, keep them on one side. Then those files which had come an earlier occasion and my notes were there, I would just glance through them for the sake of recollection and put some odd comment for me to recollect, oh, this is that matter or this is the other matter. Out of those you would again divide that these require some more reading. So you would put them aside. So by 7:38, you would have gone through some of these files and you would have made your bundles, which are supposed to go back home. So in between, say, let us say 6 o'clock or 6:15 to 8:15 or 8:30, you are either going to be dictating some short orders. There's not enough time for a lengthy order. But if you have disposed of 5, 7, 8 matters during the day with some lengthy orders, those are going to get accumulated. And by the end of the week, you will have 20, 30 such orders besides the judgments which you have reserved. If you are used to reading at night, then you will read your files. That takes you to the end of the day. And we all wait for Saturdays, not because it's a holiday, because on the Saturday at least you have to look at your reserved judgments. You are correcting those judgments which you carry back every day in a file called drafts, wherever there is little time. I mean, I can tell you that sometimes you go to the doctor with a family member, but you will carry that file with you. So if you're sitting outside, you will correct the draft and you will keep putting it there so that it goes back and it's redone. The same thing happens on a Sunday morning. Whether you have a large lawn and you have flowers or whatever you may say, yes, it's there. But it's not there. You're just sitting and enjoying yourself. You are enjoying yourself, mind you. You must enjoy your work. But wo thela filon ka will go with you wherever you go. Same thing is summer holidays. If you are traveling for 10 days, that's your holiday. If you are traveling for 1 week, that's your holiday. If you've traveled for a month, it's your holiday. If you are not traveled, your car will be in the judge's parking every single day. And sometimes we have not taken LTCs, not gone because of some pressure of work. So it's not easy. It's from an outsider's point of view, it's all fun and play. So, there have been suggestions that out of these 5 working days, there should be 1 day for judgment writing.
That makes an excellent point because we did some analysis that USA, Singapore have only 110 to 125 officiating days of working. Rest all days are meant for these contemplations only. And exactly the fact that you are saying that, you reserve 8 in a day, they reserve 8 in a year. So, I mean...
See, sometimes the quality of the judgment takes a hit. But then if you get too much into quality, then there'll be only X number, no? Yeah. So sometimes you have to dispose of with shorter orders. May not require that much of research, does not require that you get into 100 of pages or 50 pages or 40 pages. You can pass a shorter order.
Yeah. That's actually a very interesting point. Going ahead, I mean, there is, of course, a need, there is a lot of debate about how judgments don't necessarily have to be 500 pages to make sense. Similarly, even for argument's sake, that, not necessarily lawyers have to be given a long, rope to argue for many days together. How do you see, because this challenge will remain to us and will only increase, how do you see, what would be the better steps to ensure that?
You see, dictation in court is one of the best solutions. At least you dictate the facts in court in front of both the lawyers. Right. The facts are dictated, the submissions are dictated. Nobody can say, see, that written submission which comes is thanks a lot to Mr. Computer. They go into 100 pages, 50 pages, 40 pages. You limit the pages, the print becomes thinner. So everybody wants to throw out everything. Same as with documents. We are seeing the same thing in arbitrations now. Arbitrations are now going on also like civil suits. Every arbitration, there's a section 17. Lengthy arguments. Then how do you make that period of 18 months work? The section 17, they are contentious issues. Technical issues. They take time. So, and plus availability of lawyers. So, judges' life, yes, there is criticism that you see them in inaugurations, you see them. See, I don't subscribe to that view of judges' life. Judge should be like a hermit. If he's in a hermit, he won't know what's happening in the outside world. He better know what's happening. Judge should be aware. Should know what are the sensitivities.
In fact, for the younger lawyers, I have another question because I know you're doing a lot of arbitrations as well. And you made an interesting point about that how, because of unavailability of a lot of lawyers, these arbitrations are also taking too much time. we also see that there is a new branch of, I mean, even the courts are promoting to some extent that younger arbitrators can also be appointed for, let's say, smaller disputes or disputes which are not very technical in nature. So let's imagine that I am 23-year-old, right? And I am not from a family of lawyers. What advice would you give me to, if I want to be an arbitrator, let's say by an age of 28, 29 with DIAC or, some of the more reputed organizations?
See, you can apply in DIAC, etc.
Yeah.
But I would suggest 23 or 25 is not the best age to become an arbitrator.
At, say, 29, 30, I'll become.
But slowly, yes.
Yeah.
Courts again.
Yeah.
So many judges appoint lawyers as arbitrators.
Correct.
They are watching.
Yeah.
They are seeing your capability.
Right.
They know that this boy has been appearing regularly.
Right.
He will be able to manage. He understands. That's your pass. So the choice is either sit in the courtroom or sit in the canteen.
Right.
At our time, we followed lawyers.
Yeah.
From the parking, we would see that Soli Surabji or Mr. Fali Nariman or somebody of that stature, Mr. Palkiwala has come to the Delhi High Court, follow him. Copy the way he argues. Copy how he takes a question from a court.
Right.
किसी किताब में तो नहीं लिखा.
That's true. To emulating some of the most successful lawyers would also be a good starting point. But I mean, there are some lawyers, some set of lawyers who actually end up having you probably would see them far more often in, let's say, international arbitrations or national arbitrations. Whereas maybe some of the better lawyers who may have argued that well in court are not able to have that kind of arbitration practice. So, I mean, if there is a suggestion for people who want to have
now there is a very strong arbitration bar.
Right.
But then again, everybody doesn't get that level of arbitration. Right. So when there is a different level of lawyer and you tell him that, we'll take up the matter at 11 in the morning, he shows his complete helplessness. He says, listen, मेरे रोहिणी में केस लगे, मेरे द्वारका में लगे, साहब मैं 11 बजे नहीं आ सकता. I can come only at 4:35. And how many matters can you keep at 4:35? Right? So, but you can't blame him. He has one or two odd arbitrations. You can't tell him कि फिर तुम matter क्यों ले रहे हो? Fact is, he has to run his house also, no? Yeah. See, this is on the sensitivity side of it. Right. You can say, look, मैंने तो नहीं ठेका उठाया भाई, आप जैसे भी हो, आपको आना है. Yeah. See, one lawyer he called me and said, please adjourn the matter. So I said, what happened? He said, this due to pollution, they have stopped these particular type of cars, and I have an old car. So my car is off the road. Yeah. So I can't come. I stay in Rohini. Yeah. So for a minute, I was taken aback. Everybody doesn't have a hybrid. Yeah. Everybody doesn't have an electric car. Everybody doesn't have a new car. Right? So this is a mixed bag.
Yeah. Considering the fact that you are seeing a new branch or breed of specialized lawyers who are probably doing better in arbitration than the others, I mean, what would you suggest to be the key takeaways for them to get there?
See, the same is as any other work. Right. How would you take on criminal cases or writ petitions or tax matters? Yeah. There has to be a breakthrough somewhere.
Yeah.
Some people, join tax lawyers for interns, etc. Then they develop a liking for that branch. Then they work on that subject. Then they start getting some work on it. Yeah. Same way would be in arbitration. You assist an arbitration lawyer, you go to arbitrations. Then ultimately, some lawyer may see, all right, this is a smaller arbitration. Or somebody may say, this is a bigger arbitration and I find him useful. And you can say, all right, why don't you assist me? And then slowly, you start getting that kind of work.
What do you feel about there's a new crop of, associations and events which have come up in a big way. How do you see that playing a role in becoming more popular in a particular sector or maybe in arbitration for that matter? Because we saw the Delhi Arbitration Week that went on for almost a week.
See, people read papers, right? They participate. Things are deliberated upon, discussed, talked about. Some are not as close to reality. Some things are, more academic, which are also important. But practical issues are there. Like I said, time is one great practical issue. It's more flexible. It's more informal. Though you say rules of evidence will not apply, strictly CPC will not apply, but you are guided by those. You have to follow them in a way, right, directly or indirectly. You can't ignore them. You can't ignore 38 Rule 5. You can't ignore 39 1 and 2. Principles are identical. So, these seminars, conferences do highlight
Your good work.
not your good work. They are more on the academic side.
Yeah.
What are the pitfalls?
Yeah.
How can there be improvements?
But if you were a speaker on such an event, you think that'll make a difference in the kind of arbitrations you get?
I've never thought on those lines, Varun, to tell you the truth.
Yeah. You don't see that to
I-
be a gateway. I'm only
I
trying to
don't-
discuss gateways for lawyers to be better.
Lawyers can look at it because it's their first innings. For judges and all, there is
No, I'm only asking from. Please don't get me wrong. I'm only talking from.
Yes, they can certainly, if they participate,
Yeah.
they expose themselves, they expose their knowledge.
Yeah.
Certainly, it's
Enabling.
yes, certainly.
Enabling
There are
knowledge.
certain lawyers who've been able to do so. They have made a mark.
Because you mentioned about academic versus reality. Tell me, in heart of your heart, if you have, let's say, a nephew, right? And that nephew has got a startup, he's doing well, and he has just roped in his first big investment. Would you, and maybe that investment is from an organization which has some stakeholding of a government person. So I'm trying to make it as vivid as possible, this whole thing. Would you advise him to have an arbitration clause in his investment treaty, or would you not?
I think I would.
You would?
See, somebody made a comment that, he felt very unsafe when a retired judge is an arbitrator. I don't see how that can be justified, and how a person's personality or a person's integrity can change from a sitting judge to a retired judge. And such people should know that everybody is not up for sale, right? And if you can say something, you should say that means you're saying the same thing about a sitting judge, because it's only a date away. This is the best part about any such appointment. The day you are appointed, your date of retirement is fixed. Whether it's High Court is 62, Supreme Court is 65. So how does it change anything? Right?
No.
So if you were an honest judge, you would be an honest retired judge. If you were a dishonest judge, you'd be a retired dishonest judge.
Correct.
If you're an honest lawyer, you would be an honest lawyer. If you're a dishonest, you'll be whether you become a senior or you don't.
Yeah.
Right? So again, and
Yeah.
plus,
Yeah.
who appoints the arbitrator?
Correct.
Either parties,
Or the court.
right? If parties, then there is a presiding arbitrator. And if it's the court, then it's the duty and responsibility of the court to see whom they are appointing,
Correct.
right?
Yeah.
So I don't see any difference. I would certainly say that go for arbitration. Why I would say so? See, a civil suit is definitely likely to take much longer. So if you are unable to complete within 18 months, it may take 2 years, it may take 3 years, it may take 4 years, depending. See, sometimes there are complications. Parties are added. So many things are there in it. 17 comes up. Amendment comes up. Right? Then there are many 34s, and sometimes there is a block there. But the way the law has developed, and we keep repeating in our orders and judgments, that 34 is not to be taken as an appeal. If the person has gone wrong completely, either on facts or on law, or if he has somehow misread,
Yeah.
although they say if 2 views are possible and the arbitrator's taken 1 view, then you have to go by that view.
Correct.
And I see nothing wrong in that.
Yeah.
But I also feel if there is something wrong in the view, then there should be remedy to it.
Yeah.
The court should be able to remedy it.
That's true. I'm actually, I wasn't so much so on the judicial interference. I was more on the lines of, and neither was I on the independence of a judicial member. I, by no means, I mean, I love my profession. I would not be in it if I thought that it was any other way. I was more from a practical execution perspective. Like, I know I can say for myself, I've got awards against PSUs. They just sit there and they don't implement it. The execution also takes forever for that implementation to take place. I'd rather go and raise jurisdiction against them, get it faster.
See, the thing is, if somewhere we lack anything, it's implementation.
Yeah.
Like the CPC is a complete code in itself.
Yeah.
right?
Yeah.
And if you follow it,
Yeah.
everything is accounted for.
Yeah. Correct.
I mean, I've always been saying there was no requirement of having this debt recovery tribunal, etc. You just had to tweak Order 37.
Yeah.
That would have been the end of the matter.
I think Order 37 is a great remedy.
It's a great remedy,
Yeah.
right?
Yeah.
But we come to implementation.
Yeah.
Again, our laws, the way they're perfectly in place. Implementation. See, under the old act, an award had to be made rule of the court. That used to take years. So, first you moved an application for making award rule of the court. Then notice would go. Arbitrator would file the record. Then they would say award is made rule of the court, and then execution. That has been done away with. Now the award can be executed straight away. Now, if there is an award against the PSU, there should be no element of chasing. See, unlike a person who's vanished, that is difficult. Anywhere in the world, if you can't find the judgment data, what will you do?
Correct.
But if there's a PSU, etc., I know of cases we've got the chair of the chairman DDA attached many years back. That's symbolic. Attaches AC. Symbolic. That once it reaches them, then they will either file an appeal or pay up.
But that's only bold people are able to take that decision. I don't see. I mean, at least I have not had an execution where some people are ready to pass orders.
Make an application. Say that.
But I mean that's what I feel to be the bigger challenge. That I think as of now, the other leg of that's a very interesting topic that you raised about the finer aspects of 34 and what. Like if you compare it to other Western countries, what is the level of interference? But I mean, it's twofold because ad hoc arbitration is also a lot. So therefore, interference is also necessary at some level.
It is necessary in some level. In some cases, it is necessary. I am saying where it is necessary, the court is neither powerless nor should be powerless. Where you see some stink somewhere, you should be able to pass orders accordingly.
We also want to obviously discuss about mediation because we know you championed it while you were there as a member judge as well, and you took a lot of bold initiatives as well. I want to understand this, that mediation now anyway is spoken, the current Chief Justice has spoken, the last Chief Justice has spoken, there are lots of initiative, there's a new act, but there is still a lot to be desired. In the sense, Section 12A is almost a non-starter in terms of most of these cases that you see. Families have been loggerheads with each other for almost 30, 40 years. Sitting High Court judge, sitting different court judges have tried to interfere and resolve such family disputes, but they're not being resolved. So how do you see actually mediation really fructifying into, or what are the things which you think be necessary?
See, first thing I want to tell you is mediation can't be kept in a box. It can't be restrictive. It has to be diffused. 12A is one way of doing it, right? I had even suggested that in every summon before the amendment, you should put a flyer saying that this is an option to you. Because people don't know what is mediation. And I have often said during mediation, it's very important for a mediator to explain because the client doesn't understand. He feels, firstly, I went to the lawyer. Lawyer took me to the judge. Now we have all know that there are courts in India. But we don't know that there is something known as a mediator. So he's completely taken aback. In fact, there is a great sense of insecurity that here I am put before an unknown entity whom I have no idea. He's not a judge. And I'm supposed to go and talk to him. So that's where the training of the mediator, which is extremely important. He has to explain who is he, what is his role. He has to explain that he is an independent person. He has to explain that he is not going to force him into a settlement. He is not supposed to get into a settlement with the parties. He is only supposed to show them the light. He should give them an opportunity. He has to make it clear that I am an impartial person. Right? So at that stage, but don't forget one thing. In all disputes, there are three actors: plaintiff, defendant, and the judge. Right? Now, if one of the parties is not interested, there will never be a settlement. But don't forget one thing. If one party is interested in delay, he will jump for the mediation. and then delay it. Here comes the role of the judge. Firstly, do not mark a matter for mediation without cooking it.
Okay. What do you mean by that?
You must know, you must talk and understand whether there is any scope. See, and if you find
Like if there's a bloodbath, then you should not. But if it's slightly on the edge where things can be resolved.
See, even bloodbath sometimes works. And I'll give you an example.
Please.
But what I'm saying is that if you feel that one of the parties is resisting, don't force them. Maybe it's not the correct time. Right? And secondly, keep a very strong vigil. You know, it should not be unending. You say, I'm sending you to mediation in January.
Yeah.
Come back in February to report. What happened between now and January? Tell me.
Yeah.
It's not supposed to come in writing.
Yeah.
But the lawyers should be able to tell.
Yeah.
So at least one lawyer should say, look, these people didn't even come on that date.
And the pleading should continue.
Yeah, in that case. So you should also, and I would normally say that I'm listing it on such and such date where one person fully conversant, not only with the facts, but in a position to take a decision, has to remain present.
Right.
His absence will be viewed strictly.
Right.
So that lends seriousness to the matter and not just thrown.
Got it.
कि यहाँ से तो निकलो. Right? It should not be mechanical. In matrimonial cases, you see, the tendency is, अच्छा ठीक है, सब ठीक हो जाएगा, जाओ. कैसे ठीक हो जाएगा? Matrimonial cases में झगड़ा हो गया, अरे तुम्हारे बच्चे हैं, ऐसे कैसे होगा? बच्चे कहाँ जाएंगे? अच्छा जाओ. It doesn't solve anything. Same story will happen when he and she go back. You have to get to the bottom of it. You have to understand. So mediation takes time. There has to be passion for mediation. There has to be a place in your heart first to give. I have often sat till 8:30 after court hours and mediated.
Yeah, no, in fact, I've heard from a friend also, in fact, you mentioned this about a custody matter. One of the future CGIs, in fact, sat with the parties, took them out in the Supreme Court corridors and whatnot to ensure that mediation fructifies into something.
See the effort.
Yeah. So I quite follow that proactive role of the courts and trained mediators are two aspects. But tell me one thing. I'll think and say from a lawyer's perspective that isn't mediation in that sense counterproductive for lawyers? Why should lawyers force? I mean, other than that, from a legal standpoint, that it's the ethical thing to do, but you are letting go of a case.
Let me take you to some history. During Justice Karju's time, so around 2005, I think, or 2006 early, seeds were being sown for mediation. And there was a lot of resistance by the lawyers. Same very issue. So it was decided that Delhi would be unique and the mediation center would be lawyer driven with a judges committee to overlook it. And this has been one of the most successful formulas because lawyers are involved.
As mediators.
As mediators. And not one, two, hundreds of lawyers are involved. Some lawyers are only doing mediation.
It's opening up in last branch of
it's a
specialization.
New specialization. And let me also tell you one thing very frankly. One satisfied client will send you 10.
No, I'm definitely, from the school of thought that I am, we've been trained to obviously resolve cases at the fastest because that's what gives you good reputation. But I'm generally speaking from a larger perspective that...
I have not found very many. There are people.
Right.
Because again, like I said, lawyers judges, judges judge lawyers. So you say, oh, so-and-so, there'll be no settlement. So-and-so, he or she will put in his or her best. And there cannot be any settlement without the aid, assistance, concurrence of a lawyer.
Because as a long-term reputation, this is how you gain it. Then if you get more...
And lawyers are charging for appearing before mediators. So they are not losing out on anything.
I think that's a very valid point.
They are charging, appearing before the mediator on this day, this date.
Thank you. This has been really excellent, from arbitration to mediation, from advocacy in court. And I'm really glad that we could do this conversation and have such a detailed chat about this and also learn so much about the life of a judge. It really is quite a lot.
Thank you.